is happening today. I want us to just cross over there and see what's happening at the courts. Right, of course, with regard, yes, there, right on your screens, we can see Jacque Maribe, who is one of the co-accused, together with Jowie in the murder case of Monica Kimani. And of course, remember, this case was, Monica Kimani was actually murdered on September 19th, 2018. And the family has been asking for justice. And of course, this case has been ongoing for a long time. So today is the day, of course, they will know their fate and what happens next.
I appeal for the first accused person. On behalf of the first accused person, we are ready to receive the judgment. Mr. Katwa, alongside with Ms. Nicholas and Mr. Njuguna, they continue appearing for the second accused person. They are equally ready to receive, the judgment. I also appear alongside with Mr. Ayua, who I'm holding his brief. He will be joining us shortly.
She's called Miss Papea. Together with the deceased family, we have Mr. Sebi. We are ready to check the judgment.
Okay, that's done. Start together the accused persons and also we will now begin for the matter of assistance.
Criminal case number 51 of 2018, Republic versus Joseph Julia Irungu, Jowie, and Jacque Maribe.
I believe the lawyers were sitting on behalf of their clients that are ready for the court.
Yes, that is it, my lady.
Right.
For both accused persons.
So I think we are good to go. There is a practice that I would like to attend to the hearing of these proceedings, and neighbors have been notified because of the change in the date. I apologize for that. But based on what I can see, I think there is a matter of evidence, information, and notice that the government is able to do. I had been given an indication that this judgment will be delivered both physically and virtually. And I have a confirmation as whether that is the position of assistant. That's what I was told by the other people.
There is a team from the court who was supposed to come and set up the morning.
Can you hear what he's saying?
No.
But can you hear what I'm saying?
Yes.
There is a team from the judiciary. This is the court which was supposed to come up today and set up everything in the morning. They were communicated by the deputy registrar. They were supposed to come here to set up before 8:30. But by the time we were starting, they had not yet come to set up.
Maybe they're still in the way to act.
Yes, ma'am.
Okay? So we'll proceed. I'll proceed. Now, the counsels in this matter, if I read my judgment word for word, most likely will do 4 or 5 hours. My suggestion with your concurrence is this, that I do not have to read the entire extract from an authority that I've quoted. And I do summarize the same. If we are in agreement, I can do that. And the reason is, this is a technical area. And I want to assure you the judgment is here. I will not sign this copy here because this is a copy that, in my understanding, the best of my knowledge, is not preferred for the reasons. So as soon as I'm done, I'll give it to the team to proofread it. Corrections and for errors, I am hoping and I'm available to sign the copy before end of day. Okay? So you still have an entire judgment as soon as I'm done. But if you want me to read the entire judgment, no hurry, I'm available. I will read it.
The first and the second accused persons,
Yeah, may I have
and
some
the councils on record, we concur with you and give consent that you only read the elements that are necessary so that we can be able to proceed.
Okay. So today I sit in this court to deliver judgment in criminal case filed at the High Court in Nairobi, being High Court criminal case number 51 of 2018. The Republic is the prosecutor in this matter. Joseph Jowie Irungu alias Jowie is the first accused person, and Jacque Maribe is the second accused person. I will give a factual background to this matter just to set us going and for ease of understanding. The two accused persons are jointly charged with the offense of murder. That is an offense established under Section 203 of our Penal Code, Cap 63 of the laws of this country, and that section is usually and generally read together with Section 204 of the Code. May I request that all our phones, so that I don't get disrupted, be switched off kindly? Thank you. So the particulars of the offense the two accused persons are charged with are that on the night of 19th of September in the year 2018, at an unknown time at Ramuria Gardens Apartments, Kitale Lane off Dennis Pritt Road, in Kilimani area within Nairobi County, jointly with others who are not before the court, they murdered one Monica Kimani. The information and or the charge was read to each accused person, and they entered a plea of not guilty, and the case proceeded to full hearing. The prosecution called a total of 35 witnesses, whereas each accused person offered their defense. The first accused person offering his defense through a sworn statement, and the second accused person opting to defend herself through an unsworn statement. None of them called an additional defense witness. The prosecution case is that the deceased person was at the time of her demise residing in Juba, South Sudan. She was working as a managing director of a company which was a family business company known as Millport General Trading Company Limited, which was situated and or operating in Juba, South Sudan. According to the evidence that I have been able to establish from the court record, and more specifically the evidence of PW9, the security manager at Kenya Airways, the deceased departed from Juba on the 19th day of September 2018 at 3:58 p.m. on a flight KQ 353 to Nairobi, and arrived at the Jomo Kenyatta International Airport at 5:45 p.m. The court was given the benefit of the passenger manifest, and it indicated that the deceased or the material debt used a passport number CE034168, and her ticket number was 706-200-860-623. She sat on seat number 28A. In addition to that evidence, the court had the benefit of the evidence of PW18, Teddy Mugambi Kiaria, who is the head of surveillance at the Kenya Airport Authority. Her testimony to the court was that she received a request from the Director of Criminal Investigations to provide CCTV footage of the movements of the deceased person on the material date. She then went and made an observation on the same in the company of the investigating officer, and it was revealed that when the deceased alighted from the flight, it was at 17:38:19 hours. And by 17:41 hours, she was at the immigration desk. She went to the baggage hall, picked her luggage, and exited towards the international airport stage by 17:51:10 hours. The evidence of Okech Otieno John, who testified as prosecution witness number 6, is to the effect that he operates a taxi. He received a request from the deceased person. He responded positively, and that was about 6 p.m. He picked her up from the stage using his taxi registration number KCQ 399C Nissan Wing Road and dropped at the destination, which was Dennis Pritt Road, Kitale Lane. As is expected, he was paid his dues and left. The witness indicated that before they go to Dennis Pritt, the deceased called a border rider whom she met at Nyayo Stadium, according to his evidence, and handed over an envelope to him. According to him, their time of arrival at Ramuria Gardens was about 7 p.m. And as I've already said, he was paid and left. The evidence of the prosecution protected witness number 3A is the guard at Ramuria Gardens. And his evidence is that when the deceased arrived at Ramuria Gardens, she picked her house keys and her laundry, which had been left at the sentry house by the person who was working in her house in the day, and they were left with the day guard. It is his evidence then after she picked those items, she proceeded to her apartment, which was apartment number A8. It is the prosecution case. Thereafter, the deceased was visited by 4 people on that night. According to that protected witness, PW3A, the first visitor whom we had the benefit to allow to have access to the deceased house arrived at about 8 p.m. He arrived in a taxi, and he was a male person. He was dressed in a white kanzu, a gray jacket, and a maroon cape. Upon being asked to identify himself, he identified himself as Haron and gave out an identity card in the name of Dominic Becerra Haron. His request was to be allowed to go to the deceased house. The guard's evidence is that they called the deceased to seek for authority to allow the visitor, or otherwise. They were given authority, they allowed the visitor, and the visitor proceeded to the deceased house. The next person who was in the deceased house on the material night is PW7, Lee Owen. His evidence is that he arrived in the deceased house at about 9:15 p.m. He had gone to the deceased house, having met the deceased earlier, having had a discussion with her, and he was going to pick documents from the deceased. Owen testified that when he got to the deceased's house, he found the deceased in the company of two male persons. One was Mr. Waridi, a neighbor of the deceased person, and an occupant of apartment number A9. A neighbor and an occupant of house apartment A9. The second person whom Owen found in the deceased house was introduced to him as Joe, a security officer with Interpol and Office of the President. And so, as I've indicated, the evidence reveals 4 people visited the deceased on the material night. At this point, we are at 3 persons: Mr. Waridi, a neighbor, Mr. Owen, PW7, and one who was introduced as Joe and who was cleared at the main gate as Dominic Bisera Haron. Anton Kariuki Kaka, PW16, testified that he visited the accused person, the deceased person, my apology, on the material night. His evidence is that he did not gain access to the deceased house as the deceased opted to meet him at the parking area. And the reason why the deceased opted to meet him at the parking area is because the deceased informed him that he was having guests in her house who included a guy from State House. And so their conversation was held and ended at the parking area. It was the evidence of Mr. Owen, PW7. There was a general talk as they sat in the deceased house. 3 gentlemen and the deceased. And that the first person who left the deceased house was the neighbor, Mr. Warid. It is the evidence of Owen that he was the next person to leave the deceased house. And it is further evidence of Owen that by the time he left the house at about 10:40 p.m., he left the deceased in the company of the visitor who had been introduced as Joe. It is the evidence of PW3A, the protected witness, the guard at Ramuria Gardens, that the last person to leave the deceased house was Dominic Bisera Haron, who left at hours 23:21. And that after that visitor left, no one else went to the deceased house. The evidence of PW10, the brother of the deceased, Jacque Kimani, is to the effect that the deceased who had traveled from Juba on 19th of September 2018 was scheduled to travel to Dubai the following day. But she had indicated to her mother that she would see her before she leaves. And so the family tried to reach her because she did not visit the mother. And so the brother's evidence is that since her calls were not being answered, he chose to go and check on her at her residence. He went to her house in the company of his girlfriend. And when they got to the deceased house, they couldn't access the house because the door was locked. And so they sought help from the caretaker at Ramuria Gardens. The caretaker testified as PW13, one by the name of Jowie Irungu Buruku. It was his evidence that when the deceased brother sought for assistance to access the deceased house, he instructed the gardener, one by the name Stephen Wanjohi, who testified as prosecution witness number 14, to get a ladder, as they had discovered that the window and or door to the balcony was not completely closed. So the gardener got the ladder, got to the balcony, and managed to access the house. It was the evidence of the gardener that when he got into the house, he found the television was on, water was running in the bathroom, but there was no one in the sitting room or in the bedroom. He proceeded to the bathroom and found the deceased body in the bathtub. There was a mobile phone next to it, and there was water running over the body from the telephone shower. It was his evidence, as of course would be expected. He went into shock and immediately notified the caretaker and the brother of the deceased, whom he had left outside the house. He then requested the door be broken so that they could gain access. That was done, and subsequently, the matter was reported to the police. Among the officers who visited the scene is Corporal Jennifer Sirwa, number 75179, who testified as prosecution witness number 2. Her evidence was simple. She processed the scene, and she took a total of 50 photographs of the scene. Those photographs were taken from various points, indicating various areas and items, which included but not limited to the general view of Ramuria Gardens apartments, closer view of Block A, where the apartment of the deceased was. There was evidence that there was a yellow bag whose contents were not disclosed, hanging on the door. Was a photograph to that effect. The sitting room, the bedroom, the personal effects were photographed. The body, and those photographs were produced in this court as evidence. After the photographs and the scene was processed, the deceased body was moved to Chiromo mortuary. Of course, as is expected, investigations commenced. And it revealed that several people had visited the deceased on that night. Those people became of interest to the investigators. And as that was going on, Walidi, the neighbor of the deceased person, is said to have notified the family members that he had been and was in the deceased house the night before. And he mentioned, and so did Owen, that he too was in the house, but they were in the company of one Joe. It is in evidence that the deceased brother, Kimani, knew of a person by the name of Joe, and he sought to establish from Owen, through a photograph given to him, whether that was the person who was in the deceased house, and Owen's answer was in the affirmative. Mr. Kimani testified that he knew Joe, as they were in college together at Kenya Polytechnic as far back as 2012. And that he knew that Joe was known to the sister, the deceased, and he knew that Joe had a fiancée who was in the media industry, And so he approached Joe for assistance to have the death publicized. It is the evidence of Kimani that when he approached Joe for assistance, Joe told him that he would get no assistance from the media, but opted to assist through his private company to deal with the matter. The investigations advanced. It was discovered that the first accused person had made a report at Langata police station to the effect that he had been involved in a shooting incident. And so the team that was investigating the murder case got an interest in that shooting incident report, and eventually a team from the homicide department, the Directorate of Criminal Investigation, took over the investigations of both the shooting and the murder incident. The investigations in this matter were led by PW 35 Chief Inspector Otieno. It was the evidence of Chief Inspector Otieno that in the course of investigating the shooting incident, they discovered that there were contradictory statements as to how the shooting occurred. With that as it were, back to the murder issue. The first accused person was arrested, subjected to an identification parade. It is the evidence of the prosecution that he was identified by 3 witnesses. Subsequently, the second accused person was also arrested. And according to the prosecution case, she was arrested because, 1, she was within the vicinity of the commission of the murder. According to the prosecution, the vehicle that was used in the commission of this offense was hers. According to the prosecution, she aided and abetted the first accused person by providing that vehicle. According to the prosecution evidence, she switched off her phone at the time when the offense was being committed. According to the prosecution case, she gave false information to the police about the shooting incident, and the intention was to divert their attention from investigating the murder charge. And finally, according to the police, she aided and abetted and or was aware of destruction of the evidence that will be used in the murder case through the burning of the items that were recovered, believed to have been the items used in the commission of the murder and eventually destroyed. In a nutshell, that was the prosecution case. At the close of the prosecution case, each accused person was placed on their defense after the court found they had a case to answer. The first accused person gave a sworn statement in his defense and testified to the effect that he works as a security consultant, and that on the 19th day of September 2018, he dropped the second accused person at work at 8:05 a.m. and returned home at Royal Park Estate in Langata. It was his evidence that he stayed at home until about 3 o'clock when their house help notified him that there were people from Kenya Power and Lighting who had gone to attend to an issue at the house. And so he went to attend to them, and that was done. It is his evidence that he eventually, excuse me, that he left the house at 4:30 p.m. to a place known as Roadhouse along Dennis Pritt Road, where he arrived at 5 p.m. He met a friend by the name of Jennings, who testified as prosecution witness number 8. According to him, after their conversation, they went looking for fuel for his vehicle, got fuel. He dropped Jennings back to pick his vehicle from where he had left, and he, the first accused person, proceeded to join the second accused person at a club in Westlands described as Club 4040. It is his evidence that they left the club at 4 a.m., drove home and slept. That the following day, which was the 20th day of September 2018, he dropped the second accused person at work, and that went to pick her at 8 p.m. After and before they left, a quarrel ensued between them, which spilled to home. And when they got home, the second accused person threw his things out of the house. And as he was extremely drunk, he didn't realize that he had a gun. His gun went off and injured him. That the gun was not his. It belonged to his neighbor by the name of Brian Kasaine Spira, PW 17. And so he rushed to Brian's house and told Brian to go and secure the gun. Brian went secured the gun and assisted him to go for treatment. He was taken to Langata Hospital. Langata Hospital referred him to Nairobi West, and eventually he ended up at Kijabe AIC Hospital for admission and treatment. That he was later arrested, taken to his residence. A search conducted, several items picked up, and he was charged. In a nutshell, that was his evidence. As already indicated, the second accused person gave evidence to an unsworn statement. Her evidence was that on 19th day of September, she went to work as usual, worked until about 8 p.m., and as she was leaving work, she was requested to stay on as there was an interview for the former governor of Nairobi County, Mr. Mike Sonko. She agreed to do that. She stayed there. After the interview ended, she joined others. They went to Q Lounge and eventually ended up at Club 4040 at Westlands. That they were joined by the first accused person slightly after midnight, stayed there until 4 a.m. and went home. And that the following day she went to work as usual, and that when she read the news item on the deceased's death, she did so in the ordinary course of her business as a newscaster. And so generally she denied knowledge of the commission of the offense. She denied knowledge of the deceased. She testified she had no motive to kill the deceased and that she was not there, basically advancing the defense of alibi, and invited the court to take and use the statement of PW11 Chelagat, who had testified that they were together in Westlands. Just to play back as one of the testimony and evidence of the first accused person, it was his evidence that he did not know the deceased at all. So that ends a summary of my factual background. Okay, I'm on page 15. Please drink adequate water.
I'll probably go to page 115. I'm now taking up the analysis and determination. May I, for the benefit of the councils, because I think we all come to court to give the court evidence and would really want to appreciate that the court analyzed all the evidence. I can assure you I did. I can actually read this judgment for 6 hours without a paper in my hands. Okay. So why am I telling you this? If you do not hear me read out your submissions verbatim, please wait for my judgment. I have, as a general statement, taken into account the submissions. In my understanding at this point, the key question to determine is whether the prosecution has discharged its burden of proof, which is beyond reasonable doubt that each or both accused person murdered the deceased. It is tried law in criminal cases that the burden of proving a crime lies on the prosecution to prove the ingredients of the charge beyond reasonable doubt. This is explicitly set forth in the provisions of Section 107, 108, and 109 of the Evidence Act, which is Cap 80 of our laws of the land. These provisions of law speak to proof of the existence or otherwise of a particular fact in relation to the offense under consideration. The burden remains on the prosecution throughout the trial. The rationale behind the proof of the prosecution case beyond reasonable doubt is based on provisions of Article 50, Sub-Article 2 of the Constitution of Kenya 2020, which stipulates that each person has a right to a fair trial, which includes the right to be presumed innocent until the contrary is proved. There is ample judicial authority underscoring this principle of burden of proof. I'll draw your attention to two cases that are made reference to. A case from the Supreme Court of Nigeria, Bakare versus State, and I'll just read a bit of what the court said in that matter, that proof beyond reasonable doubt stems out of the compelling presumption of innocence inherent in our adversarial system of criminal justice. To displace the presumption, the evidence of the prosecution must prove beyond reasonable doubt that the accused person is guilty of the offense charged. Absolute certainty, however, and please carry with you these words, they may be important later. Absolute certainty is impossible in any human adventure, including administration of justice. Proof beyond reasonable doubt means just what it says, but does admit a high degree of consistence with an equally high degree of probability. Allow me again to draw your attention to the case of United States versus Smith. Long citation, you can pick it. Long quotation from that case, but very important. And this is what the court had to say. The burden is upon the state to prove beyond reasonable doubt that the defendant is guilty of the crime charged. It is a strict and heavy burden. The evidence must overcome doubt concerning the defendant's guilt, but it does not mean the defendant's guilt must be proved beyond all reasonable doubt. A reasonable doubt is a fair, actual, logical doubt based upon reason and common sense. A reasonable doubt may be either from the evidence or lack of it. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. On the other hand, there are very few things in this world that we know with absolute certainty. The state does not have to overcome every possible doubt. The state must prove each element of the crime by evidence that firmly convinces each of you and leaves no doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. If you find there is reasonable doubt that the defendant committed the crime, you must give the defendant the benefit of doubt and find that the defendant is not guilty under the circumstances. Moses Nato Raphael versus Republic. Reinstates an important point. Burden of proof lies on the prosecution. But does not takes note of exceptions. A few instances, the law may shift the burden to an accused person. And they quote a celebrated case of Wilmington, which is cited under 1935. Allow me to take a bit of time on these authorities because I'm sure the lawyers understand they're important. It does recognize that although the burden of proof is on the prosecution, as we put it in our world, by every general rule there is an exception. And so, throughout the web of the English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt, subject to the qualification involving the defense of insanity and to any statutory exceptions. If at the end of the whole of the case there is reasonable doubt created by evidence, as I've already said, the doubt goes to the benefit of the accused. May I again just draw your attention to Nyanjui versus Republic. I am now back home. I've been to Nigeria and UK. I've come back home. Criminal Appeal number 96 of 2021. But that quotes our otherwise well-known jurisprudence guru, Lord Denning. Miller versus Ministry of Pension, 1947, All England's Law Reports. What did Lord Denning say? That a degree is well settled. It not reach certainty, but it must carry a high degree of probability. Beyond reasonable doubt does not mean proof beyond a shadow of doubt. I'll read that again. Beyond reasonable doubt does not mean proof beyond a shadow of doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect the cause of justice. If the evidence is so strong against a man as to leave only one remote possibility in his favor, it is possible, but not in the least probable, the case is proved beyond reasonable doubt, but nothing short of that will suffice. I have said enough on reasonable doubt. Having said what I have said and set the law as it is, I shall now turn to the charge before this court. It is a charge of murder. Section 203 is read together with Section 204. The pertinent section is 203. I quote it. Any person who of malice aforethought causes death of another person by an unlawful act or omission is guilty of murder. The above ingredients of the offense have been settled. The elements, the ingredients of the offense of murder have been settled through various court decisions. I have picked a court of appeal decision that sums up the ingredients of the offense of murder. Joseph Githua and Njuguna versus Republic, 2016 EKLR. And this is what the court had to say. Under Section 203 of the Penal Code, any person who of malice aforethought causes death of another by unlawful act is guilty of murder. It is clear from this section that the prosecution must prove beyond reasonable doubt to secure conviction of the offense the following. 1, the death of the deceased. It's important we take note of this. My judgment dwells on these ingredients. The death of the deceased. 2, the cause of that death. And for ease of understanding, in my judgment, I've discussed the death of the deceased and the cause thereof together. The second ingredient is that the appellant committed the unlawful act which caused the death of the deceased. And finally, that the appellant had harbored malice aforethought. So based on the provisions of Section 203 and the authority I've cited, I have drawn the ingredients of the offense of murder as follows. You must prove the occurrence and the cause of death. There's need to prove that death was lawful or unlawful. Most likely for the prosecution, they'll be saying it was unlawful. There is need to prove the offense was committed by the accused person. And finally, the prosecution needs to prove malice aforethought. So right away, I move to the first ingredients, the death of the deceased. It is the prosecution case the death occurred. And to prove the death occurred, the prosecution, through the evidence of PW13, that is the caretaker, the evidence of Stephen Wanjohi, P14, and the evidence of Jacque Kimani, P11, is to the effect that they were the first persons on the morning of 20th of September to go to the deceased apartment and found her body in the bathtub. We are answering, did the death occur? Secondly, we have the evidence of PW2, the scene of crime officer, produced photographs number 27 to 42, showing, among other things, the body of the deceased in the bathtub and after it was removed from the bathtub. Thirdly, we have witnesses who identified this body at the Chiromo mortuary for purposes of postmortem. They included the deceased brother, PW10, the uncle Peter Njenga, Sergeant Maina, and Police Constable Biko, both from Kilimani Police Station. And finally, we have the doctor who performed postmortem, Dr. Njenga, Peter. He confirmed he carried and performed postmortem on the body of the deceased on 24th of September 2018 at Chiromo mortuary. So from that evidence, it is the finding of this court that the prosecution have prove beyond reasonable doubt the first ingredients of the offense of murder, that the death of the deceased occurred. It suffices to know the defense did not dispute the occurrence of the death of the deceased. I now move to the cause of death. May I draw us to the provisions of Section 213 of the Penal Code, which is very long and which I've made a general reference to. And so it provides the circumstances under which the cause of death may be inferred and proved by way of circumstantial or medical evidence. And in that regard, allow me to draw your attention to the case of Benson Gunyi versus Republic and request that you look at it later. In support of the prosecution case as to what caused the death of the deceased, the prosecution called the doctor who performed a post-mortem on the body of the deceased. And this is what the doctor said, that he made an observation. It was a body of a female aged about 28 years. It was wrapped in a blood-stained wet maroon and white bed cover. Both hands and right leg had henna tattoos and sealing straps. On examining the body externally, he noted that there was an irregular, invasive wound, interior neck measuring 7 by 6 centimeters, with visibly slit trachea and airway. That there was blood oozing from the nostrils. The body was pale, an indication it was lacking blood. He saw contusions on both wrists and bruises around the wrist of both legs. Internal examination revealed that the airway had been shot through and through. The trachea had been transected at the level of thyroid glands, and the right carotid artery on the neck and right jugular vein had been severed. The doctor says that means cut through and through, and there was blood oozing from her private parts. So the doctor formed the opinion that the cause of death was exsanguination due to severe neck injury due to sharp force trauma, and that the probable weapon used was a sharp object. So based on this evidence of the doctor, it is the finding of this court that the prosecution have proved that the cause of death of the deceased. Okay. The third element I am addressing is whether that death was lawful or unlawful. Article 26, sub-article 3 of the Constitution of Kenya states that, excuse me, a person shall not be deprived of life intentionally except to the extent authorized by the Constitution or the written law. We all know that if a death sentence is applicable and the court makes an order that you go and suffer death, yes, you are entitled to your life, but once the court makes a finding, then you fall under this provision as an exception. So the question one would be asking is, now that we have established the death occurred, and what caused it, then was that death lawful? In addition to say Article 26, may I draw your attention to the case of Gusambizi Wesonga versus Republic 1948, where the court said this: every homicide is presumed to be unlawful except where circumstances make it excusable. or where it has been authorized by the law. For homicide to be excusable, it must have been caused under justifiable circumstances, for example, in self-defense or defense of property. Pursuant to these provisions and in my own understanding, I find that excusable homicides are killings which result from accident or inadvertence or done up by a person who lacks capacity to commit an offense, such as a young child or a person who is legally insane or in any reasonable defense to self or property. In the instant matter, Dr. Njenga did not testify to any circumstances that would amount to excusable homicide. In cross-examination of the doctor by the defense counsel, he stated that there was no evidence of strangulation, nor a gun or bullet wound, and there was nothing unusual in the pancreas, indicating that the blood that was oozing from the nostrils was because the throat was slit at the level of the thyroid glands, and ratified that the wound would not have been inflicted after the death, because a person does not bleed after death, as it is the heart that causes the bleeding. Pursuant to the evidence of this doctor, it is the finding of this court that the deceased did not die of an accidental or natural cause. The death was not accidental, it was not an unnatural death. Therefore, this is a clear case of homicide that falls outside the excusable homicides. And so, the finding of this court that the prosecution have proved that the death was unlawful. We are still on our ingredients of the charge. And so the next issue to determine is whether each or both of the accused persons are the ones who caused the death of the deceased. And then finally, we'll be answering a question: if they did they have malice aforethought? Because you can cause a death, but you didn't have malice aforethought, and of course, that may be manslaughter. We are dealing with death. So they need not just to prove that they committed the offense, but there was malice aforethought. I have chosen to take the path of looking at the evidence that relates to the first accused first in relation to that issue, and then go to the evidence relating to the second accused person for ease of understanding and flow of the judgment. And so right now I'm analyzing the evidence the prosecution have adduced in answer to the question as to whether the first accused person caused the death or killed, bluntly put, the deceased. Under this particular issue, I have discussed several items just for understanding of the parties. And let me just there is the issue of the cloth which the accused person was wearing. There is the issue of a stolen ID card. There is the issue of destruction of evidence. There is the issue of the gun. And so I will try and flow the issues in what I believe is a chronological manner, again, for ease of understanding. Now, if I may fast track us, I have, in answering this question, which is a very critical question and very critical part of the judgment, summarized the prosecution's submissions, summarized the victim's family submission, and summarized the first accused submissions. And Professor Nando treated me to good substance, not good in the sense that none of the other people's substance, but in terms of volume. So a bit of this judgment, which I think runs into about 30 pages or 35 pages, is really a summary of what the parties submitted, okay? But I would like to read it out in brief for us to move. And so, the prosecution, of course, advanced their case that the first accused person killed the deceased. And they did that by inviting this court to look at the conduct of the first accused person before, during, and after the murder. And inviting this court to do that, the court was invited to note the following, that one, before the murder, it is the prosecution case that the first accused person stole the ID card of Dominic Becerra Harun and went to use it to access the residence and the premises where the deceased was staying. That is the submission of the prosecution. It is the submission of the prosecution that the first accused person had extra cloth, changed into those clothes, went to the deceased house, committed the murder, changed out of those clothes, and that's it. It is the prosecution case that the first accused person armed himself with a gun to the deceased house to use it to subdue, to intimidate, to coerce her